At that time, I was alarmed that student loan debt in America had surpassed $1 trillion. Now, less than a decade later, it has climbed to $1.7 trillion. 45 million Americans carry student loan debt, and they're not just young people. 8 million are over the age of 50. Some are now learning that their Social Security checks are being garnished to pay the debt. These loans are with you for life. If you fall on hard times, forced to file bankruptcy, your mortgage debt can be discharged. Your automobile debt can be discharged. Your vacation home loan debt can be discharged. The mortgage you co-signed with your kids so they could buy their first home can be discharged. But it is virtually impossible to get relief from student loans. Why? Because student loans are one of the very few types of debt that are exempted from discharge in bankruptcy. Concept of bankruptcy is a clean start, but not if you're dealing with child support, alimony, overdue taxes, criminal fines, and student loans. I'd like to turn to a brief video that highlights the need for this conversation.
I have paid $120,000 and I still owe $76,000.
We've put off major life decisions, put off having children.
I can't afford to retire.
With interest, there's about an extra $20,000.
The United States student debt crisis is up to $1.7 trillion.
If a university degree was supposed to give you a head start, then crippling debt looks like it's going to be the ball and chain.
Student debt in the US is now bigger than debt from credit cards and auto loans, and is second only to mortgages.
The number of Americans aged 60 and older with student loan debt quadrupled between 2005 and 2015 to nearly 3 million.
Debt is penalizing millions for going to college.
That debt is a weight that has many Americans pulled down, even more so in this pandemic.
It's the federal government that holds the vast majority of the student loan debt.
It is the most collectible kind of debt there is. It is non-dischargeable in bankruptcy.
Don't forget, bankruptcy is not a crazy thing. It happens in American life all the time. Sometimes for medical bills, and they file for bankruptcy.
In America, even a bankrupt gambler gets a second chance.
The promise of the Higher Education Act that Lyndon B. Johnson worked so hard for in 1965 has not been met.
Since I announced this hearing, people have been sending me stories. Linda Navarro, veteran of the U.S. Navy, went back to school when she was 39 years old. She's now 70. She has $145,000 in student loans. She has carried this debt for 31 years. She wrote to me, "There's no way to look forward." Renisha Bradley, a single mom with 3 kids. She's a hotel desk clerk. She has $51,000 in student debt, I should say. She's trying to get it discharged in bankruptcy. The Department of Education is fighting her all the way, saying she spent too much money on buying food for her children. Lisa from Arizona, mother of 2, filed for bankruptcy in 2008, 13 years ago, but couldn't discharge her student loans. She now owes $217,000. This is new in America. It didn't used to be this way. Before 1976, student loans were treated like other types of unsecured debt in bankruptcy. If you were facing financial ruin, you could get relief. But then Congress got the idea that student borrowers were running to bankruptcy court right after graduation. This notion was based on more anecdote than data. But Congress started passing laws to make it harder to discharge student loans. From 1978 to 1998, Congress made it so there were only 2 ways to get a student loan discharge: prove you had undue hardship or wait a period of years after the loan became due before filing bankruptcy. First, it was a 5-year waiting period. Then it became 7 years. Then in 1998, Congress rewrote the Higher Education Act, and as a budget offset, tucked in a provision getting rid of the waiting period for student loan dischargeability. Under the law now, there is no length of time, no waiting period. Now federal student loans can only be discharged if the borrower proves he or she had undue hardship. Well, that's an interesting standard. How is it applied? Proving undue hardship is nearly impossible. Starting with a 1987 case called Brunner, courts have interpreted the phrase to set an impossibly high bar for relief. To pass the Brunner test of undue hardship, you have to convince a bankruptcy judge that it's hopeless that you'll ever repay, while the Department of Education or its guarantee agents are on the other side arguing against you. In 2017, the Wall Street Journal looked around for undue hardship cases. They found four cases in the nation when a bankruptcy judge discharged student debt for undue hardship. 4. I've tried for years to push the Department of Education to stop aggressively challenging undue hardship claims by student borrowers. I'm still pushing. I used the example of a quadriplegic disabled veteran. It didn't move them a bit, but Congress can. We made a mistake in 1998. Undue hardship should not be the only path to address student loans in bankruptcy. There should be another option. We should go back to how it was before 1998, when borrowers could seek relief after a significant waiting period. That system worked. That's why today I'm introducing a bill with Senator Cornyn, and I thank him for joining me in this bipartisan effort. It's called Fresh Start Through Bankruptcy Act. We have talked about this problem of student loan and student debt long enough. It's time to fix it. Our bill would restore the ability of student loan borrowers to discharge federal student loans after a waiting period of 10 years. And it would pair this reform with accountability measures for colleges and schools that have consistently high default rates. We are sending a message to these schools. You are loaning taxpayers' money to students who count on your advice. The system is broken down. Universities have to be part of the solution. Everyone has skin in the game. You are no different. This is a big moment. I've been introducing student loan bankruptcy for a long time. This is the first time it's been bipartisan. Thank you, Senator. With this bill, we see a growing bipartisan consensus that the status quo isn't working and we need student loan bankruptcy reform. I want to thank Senator Cornyn again for joining me, and I want to thank our panel of witnesses for being here today. I'll introduce them in a moment after Senator Grassley makes opening remarks.
I'm willing to take a look at your legislation. I'm going to have my remarks so related to a larger issue that I hope deals with the problem generally, not a solution to that problem, except some bills that I have in that are in other committees, because I think that we've got a major problem we've got to deal with at a larger scale. So I thank you for holding the hearing, looking at higher education and the possible role of bankruptcy for student loan debt. I want to make clear that I believe we must look at the entire higher education ecosystem to solve these challenges. Recommendations to modify the bankruptcy code would address only symptoms of a larger problem. If we don't correct the underlying causes, then we're closing the barn door after the horse has gotten out. Nearly 44 million Americans owe more than $1.7 trillion in student loans, with the average graduate having debt of over $28,000. The amount of the outstanding student loan debt has doubled in just the past 10 years. Related to increasing the amount of debt is the increasing cost of college education. In the last 20 years, the cost of attending a four-year public college has more than doubled. Going back further, since 1978, it's had an astronomical percentage increase. This is more than double the rate of inflation and shows that there is a problem with how we're funding higher education. The federal government currently owns 92% of the outstanding student loan debt, and that percentage continues to increase. Federal loans are available to a large portion of the population, regardless of the ability to repay, and well in excess of need. This provides colleges with almost a limitless supply of funding, which in turn creates no incentives for college to reduce costs, contributing to higher and higher levels of debt. Many senators have suggested looking at how to make sure schools are more accountable for the financial outcomes of their students. That's kind of hard to do because every college is different, and federal standards may affect some very positively and some negatively and still not solve the problem. I'm also a strong proponent of making sure that people who are thinking about attending higher education are fully informed. So I've introduced 3 bills this Congress, similar to bills that were introduced in previous Congresses. If we ever have a higher education reauthorization, I hope to get these included. But this would provide resources to empower students to better understand college costs so that they can limit borrowing to what they need and can afford. These bills would provide students and their families with better information about the cost of college, from initially searching for colleges through the application process to accepting financial aid. Increasing transparency and ensuring potential students have this kind of information will help lead to more informed choices and hopefully more price competition between colleges. Several members on the other side of the aisle have urged the Biden administration to cancel $10,000 to $50,000 in student loan debt. This is a questionable idea. Debt forgiveness would be highly regressive and overwhelmingly benefit the wealthy at the expense of others. The administration also lacks the authority to do this. Even Speaker of the House Pelosi herself recently said, and I want to quote, "The president can't do it, so that's not even a discussion." We must consider the moral hazard and the cost to taxpayers. The majority of Americans decide to not attend higher education and pursue careers not requiring a college degree. That's their choice. Others decide to take out loans and attend college, and most are able to afford. That's their choice. I don't think that we should ask those who did not attend college to pick up the tabs for those who did. So I urge my colleagues to look at all the factors that are driving high levels of debt in higher education and closely examine the costs associated with any reform. Those remarks do not preclude my considering legislation that is suggested this very day and the purpose of this hearing. If I could just elaborate a little bit on why I think we have this bad problem. One of it goes back to a lot of bad federal policies. If you remember, before Obamacare, the federal program was put in Obamacare to help pay for some of the costs of Obamacare, and the federal government was supposed to make a lot of money off of these loans by setting an interest rate, service interest rate. We haven't made any money off of it like it was supposed to be, but when you have banks giving out loans, I think there was more of a consideration of how much loan you should take out as opposed to what a government direct loan gives. And so we have a federal policy that encourages young people to get into more debt than they should. We also have federal policy that encourages our universities to tell students the maximum amount they can loan that they can borrow, and consequently, I think they borrow more than they should. I remember when President Mason was she was president of the University of Iowa. She'd come to my office and we'd gradually talk about this problem of student debt. She would remind me at that time, maybe the average debt was about $29,000. She said if these students would borrow what it took for room and board and tuition and books, there'd be several $1,000 less debt. My university in Northern Iowa, and I think Iowa State University, have started advising students, don't borrow all you can borrow. And I think they have reduced the average student debt by about $3,000 per year. And so some of these efforts are going to pay price, but we shouldn't be encouraging people to borrow more than they need to borrow. And we don't give enough consideration of that, so we have a bigger problem than we ought to have. I could go on, but I'm going to stop.
Thanks, Senator Grassley. Senator Cornyn, would you like to say a few words?
Yes, thank you, Mr. Chairman, and thanks for scheduling this hearing, and to all the witnesses. We appreciate your testimony in person or virtually. This is an important issue, and I think our bill, the Fresh Start Through Bankruptcy Act, will provide an important relief to students and accountability for schools. I think those have to go hand in hand. It's not hard to see that the incentives in higher education are badly broken. Teenagers are told they must borrow tens of thousands of dollars in order to get a good education and join the professional workforce. If, when they leave school, they realize they've been sold a bill of goods, that their options are limited, or maybe they just haven't been counseled appropriately when deciding what their course of study might be and what the possibility of actually finding a job adequate to repaying the debt they've incurred. And we need to change that. I'm encouraged by the development of income-based repayment, public loan forgiveness, and other initiatives that the Department of Education is providing students. This bill that I've worked on with Chairman Durbin would increase that relief by permitting government student loans to be discharged in bankruptcy after 10 years. This 10-year window would help students without encouraging strategic bankruptcy. This part of our bill helps the individual student, which is important, but it doesn't solve the institutional problem here. Some institutions of higher education, no matter the size or the name on the door, are playing with house money. They can charge sky-high tuition, pocket taxpayer dollars, and graduate students who can't find jobs. When that happens, that's simply wrong. Schools need to face a little accountability. I don't want to prevent any student from getting a loan that they need in order to pursue their education. I was fortunate enough to get a student loan which enabled me to go to law school, and I'm grateful for that opportunity. These loans can provide young people with a pathway to a better life. Many schools provide extraordinary value to their students, and I know for a fact many counsel their students about what sort of indebtedness they are incurring and what that means in terms of their selection about a course of education and the potential for remuneration from their jobs once they leave school. But schools are also selling a product for a price, and that price needs to match what these students get out of it. That's why the second part of the Fresh Act through Bankruptcy Act creates a limited risk-sharing framework for schools when enough students default on their loans and fail to continue to repay them. I believe this framework is narrowly tailored, but is absolutely necessary. Some schools have taken advantage of the American taxpayer for too long, and the students are the ones harmed by their excess. So I'm glad to see this bill introduced today. I want to thank the chairman, and I'm looking forward to building support for it and learning more and discussion in our discussions with the witnesses. Thank you.
Thanks, Senator Corner. And I think that question of accountability, as you and I have discussed before, is really part of this, an integral part of this. And I'd like to credit Senator Jack Reed of Rhode Island, who was one of our first colleagues to introduce legislation along those lines. I've told him that we've included a reference to it in this bill, and I hope he gets credit for it, as he should. So I hope that this can move forward. We have five excellent witnesses. People are trying to figure out which one's not excellent before us today. And I want to give a brief introduction to the witnesses. The first is Kwame Raoul, the 42nd Attorney General of the state of Illinois. As the state's chief legal and law enforcement officer, Attorney General Raoul has been a leader in consumer protection, working to stop bad actors who prey on Illinois consumers and students. He served as Attorney General since 2019 after serving 14 years as the Illinois State Senator. For those who want footnotes in history, it was Kwame Raoul who succeeded another state senator named Barack Obama in that particular district. He previously served as prosecutor in Cook County and as staff attorney for City Colleges of Chicago. Christopher Chapman is here as president and CEO of Access Lex Institute, a position he's held since 2008. Access Lex Institute is a nonprofit that promotes broad-based access to quality legal education. Prior to joining that company, Mr. Chapman was the president and CEO of a nonprofit student loan provider, served as vice president of the student loan originator, worked in a private practice, and as a staff member in the U.S. House at one time. Diane Barta is with us virtually, network administrator from Richmond Hills, Georgia. She and her husband, Chris, have 2 kids. She has an associate's degree and a bachelor's degree. Then she took out additional student loans to pursue a master's degree at the for-profit Ashford University. That may ring a bell, Senator. They were based in Iowa, I believe. She currently has over $120,000 in outstanding student loan debt. I thank her for being here to share her story. Dr. Beth Akers, Senior Fellow at the American Enterprise Institute, where her work focuses on the economics of higher education. Previously, she worked as a Senior Fellow at Manhattan Institute, a visiting research scholar at the Federal Reserve Board, a Fellow at Brookings, and a staff economist at the Council of Economic Advisors under President George W. Bush. Finally, Elizabeth Gonzalez, who I had the honor of meeting this morning, is the directing attorney for the Consumer Law Unit at the Public Law Center in Santa Ana, California. In this role, she provides direct representation of low-income debtors, including student loan borrowers. She serves as a member of the State of California's Department of Financial Protection and Innovation's Debt Collection Advisory Committee. She's an adjunct lecturer in law at the University of Southern California, and she is certainly welcome despite being a Packers fan. Let me lay out the run of show for today's hearing. After we swear in the witnesses, each witness will have 5 minutes for opening statements, then we'll turn to questions from senators. So I'll ask all the witnesses to please stand and raise your right hand. Do you swear or affirm the testimony you're about to give before the committee will be the truth, the whole truth, and nothing but the truth? So help you God. Let the record show that they answered in the affirmative. And we'll start off with General Kwame Raoul of Illinois.
What college you mentioned from Ohio?
Ashford.
Oh, yeah. In Clinton.
You have to get the red light on.
Well, I must have been that fifth witness that didn't get swept into the excellent category. Thank you, Chairman Durbin, Ranking Member Grassley, members of the committee, for the invitation to speak to your committee. I'm excited to contribute to the discussion of potential bipartisan game-changing bankruptcy reform for student loan borrowers, and I thank the chairman and Senator Cornyn for putting forth this measure.
This question here.
The Illinois Attorney General's office has extensive experience dealing with the burden of student loans that student loans place on consumers. In 2019, our office received over 700 complaints about higher education, most concerning for-profit schools and student loans. These high-cost schools target low-income students in their federal student loans, which are incredibly and unnecessarily difficult for these students to discharge in bankruptcy. As a result, students burdened with loans that many never will pay off in their lifetimes. Those loans negatively impact students' abilities to make important life decisions. Americans hold over $1.7 trillion in student loan debt. Nearly 30% of federal student loan borrowers default within 12 years of entering college. A major contributor to student debt load are predatory and expensive for-profit schools. For-profit schools have the worst repayment rates. A shocking 98% of programs that failed the Department of Education's gainful employment metrics, which measured students' ability to repay their loans by comparing debt to earnings, were at for-profit schools. Since I took office in 2019, we have discharged over $20 million in fraudulently obtained student loan debt for Illinois borrowers, all used to pay for for-profit schools. Unfortunately for borrowers, when the schools declare bankruptcy or seek similar refuge in receivership, funds are not available to make borrowers whole. Borrowers who need relief must be able to discharge their federal student loans. Our experience investigating Westwood College in particular and ITT Technical Institute help illustrate the difficult position these students are in. My office sued Westwood College in 2012. Despite the school's closure, the widespread discharge of students' private student loans, and my continued advocacy, Westwood students are still waiting for relief from their federal student loans. My office brought claims against Westwood for misrepresenting the ability of students with Westwood credits to become police officers in Illinois. We also had claims against the school for making private student loans they know students could not pay. These loans were loss leaders designed to bring in just enough money to evade the 90-10 rule, which requires students to get 10% of their revenue from sources other than Title VII federal aid. Default rates were as high as 90% for some cohorts. In 2016, my office applied to the U.S. Department of Education to discharge the loans of defrauded students. In 2019, I wrote the department urging it to discharge the Westwood loans. In July of this year, the department finally began to discharge some of individual applications based on evidence we provided with our application. The relief is welcome, but students need more. The department discharged loans for just under 500 borrowers, but we applied for relief for over 3,000. The tuition for Westwood's criminal justice degree was as high as $75,000. And Westwood had other similarly high-priced programs. Similar to Westwood, ITT engaged in a scheme to evade the 90-10 rule by pressuring students to take out private loans the school knew the students could not repay. Default rates were estimated to exceed 80% for some cohorts. ITT closed its doors and filed for bankruptcy in 2016. As of 2010, approximately 65.8% of ITT's revenue was derived from federal education funds, around $1.1 billion. Instead of investing these funds in the students, in 2019, ITT allocated $489 million of its revenue to profit. In June of 2019, my office, along with 44 other attorneys general in a bipartisan effort, announced a settlement against CUSA, one of the private loan providers, for more than $168 million in private student loan debt relief nationwide, benefiting more than 18,000 students. Similarly, in another bipartisan effort in September of 2020, we announced a settlement against Peaks, another such private loan provider, providing $330 million nationwide in private student loan discharges. However, just like Westwood, the federal loans continue to burden those students. Just this past April, a group of 25 states, including Illinois, submitted a group discharge application to the Department of Education on behalf of ITT students who attended from 2007 to 2010. They were all subject to misrepresentations by ITT regarding the overstated income students could expect to receive with an ITT education. I acknowledge and applaud the department's June 16 announced granting of 18,000 borrowers defense to repayment applications for former ITT students. We can only do so much in enforcing consumer laws. Many for-profit schools filed for bankruptcy themselves, including ITT and Corinthian colleges. Students deserve the same right to bankruptcy relief as these schools. The standard loan repayment plan is designed so that loans are payable within 10 years. Among those Americans who fail to pay their debt within this period are borrowers who will simply not be able to repay this debt. Under current law, the vast majority of these borrowers are unable to discharge their student debt in bankruptcy. Allowing student loans to be freely dischargeable after 10 years from the time they first became payable serves two key purposes. It provides relief for Americans experiencing the most financial strain and who are otherwise eligible for bankruptcy relief, while also protecting solvency of governmental student loan programs. As to the theory that those might strategically seek out such bankruptcy, there are ample provisions in the Bankruptcy Code to guard against fraud, bad faith, and abuse to ensure relief is limited to those debtors who deserve relief. Discharging such debts will allow these former students to have the lives they may have been putting off, buying homes, getting married, and even starting families. Further, I strongly urge the committee to ensure that institutions are held accountable for failing to provide students an affordable education by tying bankruptcy discharges to institutional finances. Aligning its incentives at institutions with students' financial success was a recommendation made by the Senate Committee on Health, Education, and Labor and Pensions in its landmark 2012 report, and also a goal of the Gainful Employment Rule. Failing to hold these predatory institutions accountable does nothing but line the pockets of shareholders at the expense of taxpayers. Struggling borrowers have been waiting long enough. The time for a reform is now. I thank you for the opportunity to speak today, and I look forward to answering questions.
Thank you very much, Attorney General. Mr. Chapman?
Thank you, Chairman Dermott, Ranking Member Grassley, and the members of the committee. And thank you for the chance to testify about the treatment of student loans in bankruptcy, as has been mentioned, an often overlooked component of the higher education financial landscape. Again, my name is Christopher Chapman, and I'm the CEO of Access Lex Institute. We're a nonprofit organization with a membership comprised of the nearly 200 state-assisted and nonprofit law schools approved by the American Bar Association. Access Lex applies its resources to expand access to law school while working to increase its affordability for the value of, increase its affordability and value for the benefit of aspiring lawyers and ultimately the society they'll serve. As has been mentioned, reform of the bankruptcy process is necessary to address the negative consequences resulting from what is effectively a judicial failure to adapt to legislative changes over the last 30 years. By effectively remaining static in spite of those legislative changes, the test for undue hardship has morphed from what could be arguably an appropriate basis for analysis and application of the law to an overly strict and uneven exercise, even for those small percentage of people who successfully navigate the procedural hurdles, which serves to frustrate the underlying goals of both the Bankruptcy Code and the Higher Education Act. So I'm pleased to offer a proposal today that we've been pushing for almost 7 or 8 years that appropriately balances the important interest implicated by the discharge of student debt in bankruptcy. It is a little different than the Fresh Start proposal that I just heard about this morning, but it's offered in the same spirit. In other words, to fix a problem that exists, that doesn't have to exist, and can be remedied in fairly simple legislative ways. We've long advocated for responsible borrowing, offered quality counseling, and encouraged diligent and timely repayment at Access Lex Institute. To that end, we offer many extensive financial education programs for our member schools and our member students, beginning with pre-law and going all the way through repayment. These services include our Max Financial Education Program and the ability to talk with accredited financial counselors one-on-one. We believe it's a great model for what others can do more broadly in the higher education sector. However, we also recognize that access-driven student loan programs will necessarily produce some borrowers who are unable to pay, often for no reason of their own. And until we have a working crystal ball, defaults in the student loan program, and in some cases bankruptcies, are a necessary cost of maximizing the intellectual capital of this country. In our view, there are 3 core factors which must be properly calibrated to maximize the efficacy of the substantial investment in higher education by the various stakeholders and the value to the country as a whole. First, the provision of equal and affordable opportunities for all who pursue higher education, which forms the basis of the Higher Education Act. Next, the ability for the honest but unfortunate debtor to obtain a fresh start, while also promoting equitable treatment of creditors, representing the core tenets of the Bankruptcy Code. And finally, the ready availability of capital to allow Americans to reliably and affordably pursue their education dreams, a factor equally applicable to both the government as a lender and private sector lenders. So in this spirit, we propose a return to the framework that existed prior to the 1998 amendments with one substantive addition. Specifically, we propose that undue hardship standard remain, but only for loans which either first enter repayment within the 7-year period preceding the applicable bankruptcy filing, or loans which, without regard to time and repayment, are eligible to participate in an income-driven repayment plan, providing for monthly payments no greater than 15% of discretionary income, with loan forgiveness available for a period no longer than 25 years. All other student loans will be evaluated in bankruptcy proceedings consistent with other consumer debt. In addition, we strongly encourage Congress to revisit the definition itself of undue hardship. Congress has never defined this term, and the judiciary's attempts have resulted in an unduly strict standard that is unevenly applied, only exacerbated by the elimination of the limited waiting period in which it was applied. For example, creating clear guidelines for the minimum standard of living and establishing safe harbors for certain types of expenses in the analysis, like caring for a sick parent, could help rationalize the undue hardship analysis with the realities of today's borrowers, who have larger loan balances and longer repayment periods than those of prior decades. In sum, we believe our proposal effectively balances the interest of all parties involved to support a vibrant loan structure that encourages opportunity, access, affordability, and personal responsibility, all set against appropriate and acceptable capital risk for the private sector and taxpayers alike. Thank you very much for listening. I'm happy to answer any questions that you may have today or as the committee works to advance these efforts at student loan reform in the future. Thank you.
Thanks very much, Mr. Chapman. We'll go to 2 virtual witnesses, Ms. Barta and then Dr. Akers, and Ms. Gonzalez will wrap it up. Ms. Barta?
Chairman Durbin, Ranking Member Grassley, members of the committee, good morning. My name is Diane Barta. I'm 50 years old. I'm a network manager living in Richmond Hill, Georgia. I've been married to my husband, Chris, for 12 years, and we have 2 children, Reagan, 10, and Carter, 5. I have over $120,000 in outstanding student loan debt. I began my education at Central Technical College in Macon, Georgia, where I received an Associate's of Applied Science. I then transferred to Troy University, where I completed a bachelor's degree in Applied Science and Technology Management. Upon completing my bachelor's, I started working in technology for the school district, but I wanted to teach, so I undertook a master's degree. In 2011, I enrolled in Ashford University online. I had also done my undergraduate through Troy University eCampus, so I was comfortable with the online structure. I had a Pell Grant to help me pay for my associate's degree, but I also had to take out loans as well, and for the rest of my schooling because neither of my parents could afford the cost. In fact, I'm the only one of my siblings who attended, let alone completed, college. And although I had to take out some loans for the undergrad, the price tag for Ashford University was much higher. It required me to take out almost $54,000 in loans. And that is in addition to the $30,000 loans from associate's and bachelor's degrees and almost $36,000 in interest. You may be aware of Ashford University, which has been under scrutiny and lawsuits because of defrauding individuals. It started as a small Catholic liberal college in Iowa. Then Bridgepoint Education purchased it and turned it into a for-profit online school, took it public, and shut down the Iowa campus. In the meantime, it sold many students, including me, on the idea that it would provide a high-quality education in a convenient manner. In fact, I enrolled in Ashford because the recruiter told me that the program I was starting, a master's in teaching and learning with technology, would allow me to begin teaching online right after I finished. I have applied for many online teaching positions since completing my degree and never even been offered an interview. I now know that Bridgepoint and Ashford have been investigated and sued by 5 separate states and at least 3 federal agencies for lying to students and others. In 2012, my husband lost his job as a commercial plumber. And at that point, 100% of the bills and vehicles and everything was in my name. So when, without his income, we couldn't make our payments, I had to file for Chapter 13 bankruptcy. I cried when I did it, but we didn't have any other options. And then I found out from the lawyer that I couldn't include my student loan debt, our biggest debt, in the bankruptcy. Despite paying back for 5 years, I still have $120,341 in student loan debt. And even my husband eventually found a job, we are still not able to make the monthly payments on student loan, which are over $1,000. I have tried to find other ways to reasonably pay back my loans. I've tried to enroll in the income-based payment. However, I was told I made too much and didn't qualify. But who can afford to pay $1,000 a month for student loans, especially when trying to raise children? I put my loans in forbearance twice to avoid defaulting. I have also applied for borrower's defense repayment for the debt I took out from the worthless master's degree at Ashford. And my payments are currently paused because of the pandemic. But I worry what will happen when the pause ends and I still can't afford the high monthly payments. Will the government garnish my wages? How can I afford to support my family? I could have discharged my loans in bankruptcy. As painful as the filing was, it would have ultimately been a great relief. I wouldn't still be having sleepless nights worrying about how I'm going to pay and what happens to my children, my husband, and me if I cannot. Thank you.
Thanks, Ms. Barta. Dr. Akers?
Chair Durbin, Ranking Member Grassley, and members of the committee, good morning, and thank you for inviting me here today to share my thoughts on this important issue. For the typical borrower, access to student debt creates an opportunity for economic mobility that would otherwise be unavailable. Some students, however, are left worse off financially for having gone to college. The political discourse surrounding student debt would have you believe that unaffordable student loans are inescapable, but that's pretty far from the truth, at least for borrowers with federal student loans, which make up over 90% of the outstanding loan balance in the nation. Over the past decade and a half, policymakers have built a comprehensive safety net that gives borrowers a break when their loan payments are unaffordable. The Department of Education's income-driven repayment plans allow any student borrower to set his or her monthly payments to an affordable percentage of his or her monthly income without penalties. Borrowers whose debt remains unaffordable over 20 years will have their remaining balance forgiven. While it can be difficult to choose from and enroll in income-driven repayment plans, these plans are appropriate for the policy challenge at hand and can bring huge financial benefits for those who qualify. However, because IDR is administered across a complex variety of programs, each with different criteria, program parameters, and payment calculations, the system can be excessively complex to navigate, with many borrowers unaware of the benefits available to them. While the protections through IDR have been expanding, protections available through bankruptcy have declined. Over the past 30 years, a series of policy changes have made it more difficult for borrowers to have their student loans, both federal and private, discharged in bankruptcy. The motivation for the special treatment of education debt was that investments in education could not be transferred. The borrower would always retain the benefits acquired from their education. This exception would make sense if investments in education paid off uniformly with large dividends. But the reality is that some investments in education fall short of that mark, unpredictably offering little or no value to the borrower. In an economy that relies on largely self-financed investments in education as the primary mechanism for social mobility, it is untenable for students to have to risk their financial well-being without a robust safety net. In the past, I have argued that it would be unnecessary for Congress to reconsider allowing for student loans to be discharged in bankruptcy due to the more nuanced safety net that IDR now provides. However, IDR is in need of serious reform. In the meantime, reinstating the option to have student loans, both federal and private, discharged in bankruptcy under certain conditions would create an effective patch to the well-intentioned but inadequate IDR system. The concern with allowing student loans to be discharged in bankruptcy is that some borrowers might use this option strategically, borrowing to pay for school and then entering bankruptcy as a less costly option than repaying their loans. The introduction of moral hazard is inevitable, but can be mitigated through restrictions. For example, requiring a borrower to be in repayment for a number of years before the loan becomes eligible for bankruptcy would reduce the financial reward of bankruptcy while also increasing the cost. It would also be reasonable to require that borrowers with larger balances, like those from professional and graduate programs, would be required to pay for a longer period of time before their loans would become eligible for discharge. One consequence of allowing private student loans to be discharged in bankruptcy is that it would likely reduce the amount of credit available to students, with economically disadvantaged students being affected the most. The equity implications of this change might seem concerning, but they could actually be beneficial to borrowers. The loans that will no longer be made were likely unaffordable in the first place. Additionally, those who continue to have access to credit may also see higher interest rates. This seems to me a reasonable price to pay to allow truly struggling borrowers to be able to discharge their loans if needed in bankruptcy. Thank you for the opportunity to give testimony in this important hearing. I commend you for considering bankruptcy reform for students, knowing that it doesn't pack the same punch as flashier proposals that are on the table, but that it has the potential to substantially improve our system of higher education finance without exorbitant expense. I look forward to your questions.
Thank you very much, Dr. Akers. Ms. Gonzalez.
Thank you, Chair Durbin, Ranking Member Grassley, and members of the committee. Thank you for inviting me to testify today. I am here on behalf of Public Law Center clients who are low income. The Public Law Center is a 501c3 legal services organization committed to providing access to justice for low-income residents of Orange County. Through PLC's Consumer Law Unit, we provide direct representation to assist low-income individuals with student loans as well as with bankruptcy. Our clients are usually over 35, sometimes over 50, and in far too many cases, over 60 and above. In all of these cases, our clients are struggling to make ends meet and have almost always suffered an unexpected loss of income, making paying their bills a challenge. When student loan borrowers come to PLC for assistance, we look first at non-bankruptcy alternatives, usually an income-driven repayment plan. But despite the availability of these plans, so many borrowers are unaware of IDR programs or find the application process confusing. And so for the most part, by the time they come to us, we're able to enroll most of these borrowers in an IDR program that provides a payment that they can afford. If we're not able to enroll them in an IDR program, other students have other options, such as the total and permanent disability discharge. In many cases, however, students enrolled in the IDR program are unable to make their monthly payments because paying 10 to 15% of their discretionary income is simply not possible given the high cost of living in Orange County, including childcare. Just to put things in perspective, Orange County is at 87%. The cost of living is 87% higher in Orange County than the national average. Housing costs alone are over 374% higher in Orange County, 374% higher. So discretionary income in Orange County is anything but. The failure to make their IDR payments results in borrowers defaulting on their student loans, and in some cases having their wages or tax refunds garnished, or having a federal judgment entered in against them, making them actually ineligible for IDR programs in the future. The borrowers who cannot afford their IDR plans have additional consumer debt, usually including medical debt, that they also cannot afford to pay. My heart breaks for Ms. Barta, as her story is one that I hear far too often through Public Law Center's work. Despite being so overwhelmed by debt, my clients, they hesitate to even bring up bankruptcy in a meeting with me. There is a stigma associated with filing for bankruptcy. These students, these borrowers understand that bankruptcy makes it harder to find a place to live and means they will be unable to access affordable credit for many years. Overwhelmingly, PLC clients are ashamed that bankruptcy might be in their future. They did not plan to be unable to pay their bills, and they see filing for bankruptcy as a failure of sorts. So for the most part, by the time a debtor gets to the point of considering bankruptcy and trying to discharge their student loans, they have exhausted their options for increasing income and decreasing expenses. In fact, borrowers we work with are often unable to afford rent in Orange County and end up relying on friends and family for free or reduced cost living. These debtors are often working as much as they can and usually have some limitations as to the type of work and how much work they can perform. These limitations, however, do not rise to the level of a disability, making it unable for them to engage in substantial gainful activity. Since 2012, PLC has provided approximately 5,000 bankruptcy consultations to debtors through our bankruptcy work. Out of these thousands of consultations, PLC has only filed 5 adversary proceedings in bankruptcy to attempt to discharge federal student loans. And that's because the undue hardship bar is so high that we don't believe these other borrowers would be able to successfully discharge their loans in bankruptcy. When PLC does decide to seek a discharge of federal student loans for a client, the complaints we file detail heartbreaking facts to support a finding of undue hardship. A client who relies on friends or family for housing because they cannot afford to rent even a room in a house, and who feels like a burden on their friends and family. A client who, despite being told by doctors that they should not work, continues to work in order to pay their bills, including their student loan payment. A client who has to deny a child a trip to the movies or toys because all of their income is spent on necessary expenses, including their federal student loans. Despite these facts, these discharge cases are always contested. Borrowers are made to justify expenses such as paying for internet service and questioned about their financial situations to such an extent that borrowers sometimes just want to give up. The current system is just not working. The fact-specific demands of the undue hardship analysis places a tremendous burden on debtors, the bankruptcy courts, and frankly, government counsel. The reality is that the undue hardship standard creates arbitrary, conflicting, and unfair results that negatively impact debtors. Most circuits, as Chair Durbin mentioned, use the Brunner test to determine whether a student loan should be discharged in bankruptcy. There are 3 prongs to the Brunner test. I'm not going to go into all of them, but I do want to focus on 2 of them. The difficulty in the undue hardship analysis usually comes from those first 2 prongs. Maintaining a minimal standard of living, and that the circumstances are such that this is going to continue for the foreseeable future is the second prong. For the first prong, minimal standard of living. So while being able to afford, not being able to afford your own place to live sounds like a borrower is unable to maintain a minimal standard of living, this is actually always a point of contention in these bankruptcy cases. The reasoning seems to be something like, but the borrower has a place to live that they don't have to pay for, so what's the problem? It's as if depending on friends and family for shelter in your 30s, 40s, or 50s is a positive situation. The second prong requires the court and the government to predict the future, in a sense. Based on the past, insert however many number of years here, will that be the same in the future? Here, excuse me. While borrowers have established years of hardship, this is also a point of contention. Because did the borrower do enough to increase their income? Surely the borrower will earn more money in 5 or 10 years. But the fact is that by the time the borrower comes to PLC and we have filed a case to discharge their student loans, the borrower has exhausted options for increasing their income and has hit their maximum earning potential. Reintroducing the temporal discharge option would remove the arbitrariness and unfairness from the undue hardship analysis by, in a sense, codifying the second prong of the Brunner test. If a borrower finds themselves in a situation where they have to file for bankruptcy 7 or 10 years after the student loan became due, they have then established the situation has persisted for a significant amount of time and will maintain for the future. It actually, I'm happy to hear that everyone seems to be in agreement. All of the witnesses here seem to be in agreement that reintroducing the temporal discharge will help borrowers unable to afford even an IDR payment. There also seems to be agreement that not only won't students rush to file for bankruptcy and discharge their student loans, but that the bankruptcy system has in place protections against the abuse of the bankruptcy process. Everyone also seems to agree that the current IDR program and the system of undue hardship, that they're not working. Something has to change. Low-income borrowers, many of whom are individuals of color, are trapped in a cycle of being unable to pay their federal student loans, even on IDR plans. They default, they have wages or tax refunds garnished, rehabilitate their loans if possible, and then fall back into default. For those borrowers who have no other option, being able to discharge their federal student loans in bankruptcy is the only way to truly have a fresh start and a chance at a financially stable future.
Thank you very much, Ms. Gonzalez. We appreciate your testimony. I understand 5 minutes is not enough, and many of you have come great distances. I hope in the question period you'll have opportunities to expound. Mr. Chapman, you closed your statement by talking about Congress creating a definition of undue hardship. Something has to give here. Whatever the definition under the Bruner test is today, it practically is no relief. I mean, when you look at the other areas of non-dischargeability under the bankruptcy code, whether it's alimony or child support or taxes, that sort of thing, there is no undue hardship escape. I think Congress believed it was creating some sort of an out for the hardship case, but in the application of the Bruner test, that just doesn't work. Do you have a definition that you have created? You made a reference to some elements.
We have not created a specific definition, but it's a combination of the temporal discharge period as well as the definition of undue hardship. I think both should be addressed, albeit with the reinstatement of a temporal discharge, the undue hardship definition becomes, I guess, less impactful, but still important.
So I have tried, with no success, to appeal to the Department of Education, which is the bill collector in name, to establish some sort of reasonable standard. I use the example of the quadriplegic disabled veteran, who's in a terrible state and is never going to see a change in circumstances and needs a helping hand. It doesn't seem to touch them in any way. I believe they are contracting out some of these collection services, and perhaps there may be some perverse financial incentives to always say no. But in 5,000 cases since 2012, or 5,000 clients since 2012, you've had 5 cases only at PLC. Gives you an indication, 1 out of 1,000 that you think may even have a chance under undue hardship. Is that correct?
Just to clarify, it's 5,000 consultations, so sometimes people come in for more than one consultation, but yeah, the number is very low.
Well, and I also want to address the issue, and I think rightly so, the ranking member raised the issue of moral hazard in terms of whether or not we're going to make it just too easy to file bankruptcy and people will be taking advantage of that opportunity. You seem to make the argument, you do make the argument, that this is a tough thing to sell to a lot of people, even though they desperately need bankruptcy. It's their only escape from their current situation. And that strikes me as an honest appraisal of what most human reaction is to the fact of going through bankruptcy. People aren't happy to do it or anxious to do it in most cases, and that's been your experience.
Absolutely.
Mm-hmm. Attorney General Raoul, you've seen these schools, for-profit schools in particular, and Ms. Barta was a victim of one of them, Ashford. These schools are notorious. 8% of high school students go to for-profit colleges and universities. Over 30% of student loan defaults are from students in for-profit colleges and universities. They get into the system, they borrow too darn much money, they either then drop out or then get a worthless degree and can't pay it back, and it just keeps building in interest. You've tried to appeal on behalf of some of these classes of students with some success, I'm happy to report, but there are many of them that don't get that kind of relief or protection from the deception that they've been witnessing.
That's right, Mr. Chairman, and there's consensus among state attorneys generals. As I mentioned on some of these actions, there is a bipartisan effort to hold these bad actors accountable. And even with the limited success, there are many students who are just left without relief.
I'm going to defer to my colleagues as they've been waiting patiently here, but I think we are moving toward, I hope we are moving toward a consensus. And certainly Senator Corner and I invite others to join us in this conversation. We have talked about this student debt for how long? Decades. And we haven't done a darn thing about it in a long time. We can do something now that is reasonable and meaningful. And I think restoring the 10 years is a reasonable step in that direction. As well as accountability for the schools that are abusing the student loans from their point of view. It's been a long time since I've been a practicing lawyer, but I think about a 19 or 20-year-old young man or woman facing the prospect of $10, $20, $30, $40,000 in debt and signing on the bottom line at that point in their lives. They need some help. They need some advice. Going back to the point made by Senator Grassley, somebody's got to say to him, wait a minute. You don't need to borrow all that money, or there's another way to do this, or perhaps you ought to reassess the whole situation. They don't have that kind of counseling. It's a university selling student loans from the government, and students, many of them with no life experience to turn to, and no reliable parents may never have been to college themselves. That puts us in this predicament many times. So I think we're moving the conversation in the right direction, and I thank the panel for being here. Senator Grassley?
Yeah. I want people to think about if whether it's done by just government decision or by the bankruptcy courts, if student loan debt was forgiven, more than half of that money would flow to families in the upper 40% of income, the top 25% of households in the United States with incomes above $173,000, now holding 34% of all outstanding debt. So my question to Dr. Akers, what are your thoughts on the immediate student loan forgiveness, and do you believe that this would be a regressive policy?
I do believe it would be a regressive policy. I think it's a terrible policy idea. Not only is it regressive, but it creates bad incentives for future borrowers. I just wrote a book advising people on how to pay for college. And if this cancellation were to happen, I'd be advising people to borrow even more tomorrow than they're borrowing today. And that's the problem that we create with that sort of sweeping forgiveness plan.
I've already referred to several bills that I've introduced in this Congress and previous Congresses. For instance, my Know Before You Owe Federal Student Loan Act would require schools to inform students before they borrow about their likely debt compared to their likely salary based on their program of study. Combine that bill with the College Transparency Act, which I also support. Students would know how much they're likely to make based on their chosen major in a specific college that they attend using data from previous graduates. So Dr. Akers, do you think this kind of information could help borrowers avoid taking out loans beyond what they can afford to repay? And what do you think better information for students would do for the cost at colleges?
Absolutely. I'm a big fan of improving the information that students have available to make decisions about their investments in themselves. I think the government can only do so much in regulating institutions to ensure that quality exists and people are their own best advocate when it comes to shopping for colleges and knowing what's right for them. I would love to see people be more aware of what the value of a degree is so that they can put pressure on institutions to charge prices that are in line with value. It's asking a lot of the consumers, but I think it's some place that we can go effectively.
Yeah. Dr. Akers, do you have anything to advise beyond what I've already talked about my legislation would do?
No, not particularly. One thing I'm concerned about, especially as we move into conversations about accountability and risk sharing, is the lack of discretion that financial aid offices have to counsel students or restrict their levels of borrowing. I often speak to financial aid officers who know that they're giving loans to students that are unaffordable, but they don't have the ability to constrain them from borrowing further.
Mr. Chapman, do you have anything you'd like to add to this discussion we've just had?
Yes, thank you, Mr. Grassley. With respect to student loan forgiveness, we've never supported blanket student loan forgiveness. We believe the government's role is to provide access and opportunity and serve as a backstop for those borrowers who struggle at the back end, and we think that would be better use of money than a blanket discharge of loans across the board. For that reason and for some of the other reasons around moral hazard and the like. So that's what we would add to that.
The cost of attending college continues to increase. As I mentioned in my opening statement, the cost has doubled in the last 20 years, growing twice as fast as inflation. College continues to grow the administrative state and build lavish facilities off the never-ending stream of government money. Dr. Akers, what do you think could be done to help reduce the cost of colleges? And secondly, should schools have some sort of skin in the game to hold them accountable?
I do think that colleges should have some skin in the game, meaning their financial accountability for when their students struggle financially to repay their debt. What can we do to ease up the inflationary pressure on this? I think we need to make it reasonable for people to choose not to go to college. That's the only way that institutions will face the pressure that it takes for them to charge prices that are more in line with their value. Consumers are put pressure on all kinds of sellers of different goods to charge prices that are in line with what the product or the service is worth. And there's no reason that can't happen in education.
Thank you, Mr. Chairman.
Thanks, Senator Grassley. Senator Whitehouse.
Thank you, Chairman. First, thank you for your leadership on this issue. Attorney General, I don't know what you're hearing. I'm sure you meet with a lot of constituents in Illinois, but I want to share with my colleagues that when Rhode Island's realtors come in to see me to ask for what they need to support them in their professions, in the last couple of years, they've started raising this question of student debt. They're recognizing that there is so much student debt out there that is starting to depress their ability to put people who should be in houses into houses because they're so burdened with debt. So it's telling for me when you hear the realtors of the country coming in and saying, you really have to do something about this student loan debt because we're seeing people who we should be able to put into a house. They're at the right time of their lives, they've got the right level of income, they're ready for this responsibility, they just have too much student loan debt. So I appreciate everyone's attention to this issue. It also strikes me that while mortgages are available at 3 or 4% pretty readily, student loan debt often charges 8, 10, 12%. And I wonder if Ms. Gonzalez and Attorney General Rao could comment on that interest rate discrepancy and what that does to borrowers in an environment in which other people are getting loans at much more favorable rates.
I can speak a little bit to that. I can say that because of the IDR program and the interest that accumulates when basically you're paying less than or just interest on the loan, the borrowers who took out X amount of loans end up owing 3-4 times that amount because of that accrued interest. This is especially true for those borrowers that took out loans in the 90s or in the 2000s, and so now we're 20, 30 years out at a 6 to 7 or 8% interest rate. That in some cases the amount of the interest actually is larger than the amount of the original principal.
In bankruptcy, can a debtor and the entity holding the loan agree separately to a lower interest rate in order to allow both to continue?
So yes, there are settlement options in bankruptcy, and that is usually the way these cases go rather than going to a trial.
Yeah.
But it's a hard road to hoe in terms of convincing government counsel that this is a case that should be settled out for something, whether it's a lower interest rate, whether it's a zero payment for a certain number of years, things like that.
As a general proposition, a bankruptcy is a bankruptcy, and a whole lot of different things can put an American into bankruptcy. One of the areas where I've been doing a lot of work, Attorney General, has been on medical bankruptcies, because medical bankruptcies, it's really hard to say that there's moral fault on the part of somebody who was driven into bankruptcy by having a heart attack, by getting a horrible diagnosis, by facing an issue that puts them into an impossible financial situation that is not of their own making. It's an illness that befell them. And is it the case that the student loan debt is non-dischargeable, Attorney General, whether or not that's the cause of the bankruptcy?
Well, the issue you raise about moral fault, the notion of sort of characterizing somebody who's trying to attain a higher education, knowing the differences in income between those who attain higher education as juxtaposed to those who don't.
Who would not want to do that, right? That's
exactly.
the thing to do.
And the idea of being able to characterize one who seeks out that higher education and the loans as a result of being in moral fault for
even people do make that point. Nevertheless, I agree with you, but people do make that point, and I think medical debt is an example of a place where nobody can make that argument fairly. If somebody has a terrible, terrible diagnosis, then that changes their lives and it can wipe out their finances. And if they need to go into bankruptcy, that will be what drove them into bankruptcy. And there's a bankruptcy judge sitting there and saying, I'd really like to help you out, but there's this law about your student loan. Even though you were perfectly good about paying it back, even though you intended to, you got wiped out by something else. Even then,
yeah, you're absolutely right, Senator. And I'd like to go back to a point that you made at the outset and that Ms. Gonzalez touched on as you talked about the realtors in your area. These student loan burdens prevent people from what we as Americans believe is living out the American dream, being able to purchase a home, start a family, educate your kids.
Yep.
It's a burden preventing them from doing so. As a result of the higher interest rates, many of these borrowers will have that burden for the rest of their lives.
Well, my time's up, but I want to thank the chairman and I want to thank the whole panel.
Thank you, Senator Whitehouse. Senator Cornyn.
Thank you, Mr. Chairman. Thanks to the witnesses for being here. I know there have been a lot of different efforts made, including in my state, to try to provide students with multiple options when approaching their education. Obviously, for people who don't want to go to a four-year liberal arts college like I did, they can train for a trade, welder, plumber, which are in high demand and well compensated. There's a lot of opportunities there. Or you can, in my state, and I'm sure it's typical of most states, you can get college credit while you're still in high school if you're so motivated. Our community colleges offer the best bang for the buck, I think, in terms of low-cost education. And then again, and I'm sure my state is typical of others, in that the pipeline that is then created for people who want to pursue a four-year college degree and beyond. And we've also seen some interesting entrepreneurs, people like Steve Klinsky, who started something called Modern State Educational Alliance. There's so much content that's available online now, actually provided by some of the most famous universities in the world. And he started something called Free First Year to try to find some way for students to access that free content from these outstanding educational institutions and actually get credit toward their degrees. So there's a lot going on in this space because of the concern we all share about the burden of student debt. Ms. Akers, I'd like to just ask you, Dr. Akers, sometimes people have suggested that the fact that that government student loans are available almost without limitation and without really assessing the ability of the student to repay or the course of study they take is actually causing inflation in tuition costs at our colleges and universities. Do you agree with that or disagree? Would you comment?
I do believe it's true. In theory, economics tells us that subsidies raise the cost, raise price. That's simple economics. But access to loans is really someone spending with their own dollars. So it shouldn't necessarily have that inflationary pressure. But the reality is that when you survey students shortly after they signed their first promissory note, they have no sense that they have even borrowed sometimes. So it seems very likely to me that the escalating availability of student debt has contributed to tuition inflation over time.
Attorney General Raul, you've got 1, 2, 3, 4 former attorney generals up here, and a lot of recovering lawyers. But I'm concerned, and I know this is something that Chairman Durbin has spent a lot of time on, some of these for-profit schools, but in particular, those who target veterans and others who have GI benefits and the like, and take advantage of their naivete, perhaps, about what they will actually learn, whether it will allow them to earn a living or the like. Could you just talk a little bit about the consumer protection aspects of not only misrepresenting what sort of educational benefit you receive, but also perhaps maybe the importance of having the school itself have some skin in the game or have some responsibility to counsel their students, to help them along the way, to help them understand, well, just because you want to major in basket weaving rather than computer science, maybe you ought to think about what your prospects are for the future in terms of your ability to pay your outstanding student debt.
Absolutely, Senator, and I don't know whether to call you Senator General, because skin in the game is important. I think the gainful employment rule was a means of trying to create that, but it was gamed as well, as I talked about in the two examples I presented in my opening remarks, and as I mentioned, we as attorneys general, state attorneys general, on bipartisan basis, try to use the consumer protection tool to protect students, but it's limited in what it's able to provide. Ironically, these for-profit institutions can seek refuge by way of bankruptcy in a way that the students that they prey upon cannot. So that's why I'm here, and I appreciate your effort as well as the chairman's effort to try to address this.
Ms. Gonzalez, let me just ask one last final question about the consequences of bankruptcy. I know there's concern about the moral hazard that people will borrow the money and then, knowing they can declare bankruptcy, perhaps trying to declare bankruptcy. I think the bill that Senator Durbin and I have proposed with a 10-year delay before that can happen addresses some of that moral hazard. But can you talk about the other consequences to an individual who declares bankruptcy? If you declare bankruptcy, it doesn't just potentially discharge your student debt. It has a lot of other consequences for an individual as well, doesn't it?
Yes, Senator. So some of the big ones, the bankruptcy stays on your credit report for 10 years. So anyone who's pulling your credit report will see that you filed a bankruptcy. And that stays on for 10 years, which is very long, a very long time. Access to credit. So it's not so much that someone who has filed for bankruptcy won't be able to access credit. It's that they will be able to access credit at very high interest rates. So someone who maybe didn't file for bankruptcy, who could get a car loan for not the lowest because their credit's not the greatest, but 7%. After bankruptcy, you're looking at a 22% interest rate for a car loan. There's also a housing aspect to it. Even though technically maybe landlords aren't supposed to use the filing of a bankruptcy as a reason to refuse to rent somebody, it's looked at in the context of the credit worthiness as a whole, whether someone is going to be able to pay their rent on time. In some cases, employment is also affected. So at least in my state in California, there are certain job categories where an employer is allowed to look at your credit without any reason. And so a bankruptcy can affect your employment prospects. And practically speaking, a lot of employers ask for permission to pull the credit report, and providing that permission, now the employer can look at a credit report and see the bankruptcy and what does that mean for this person in the future. I think those are sort of the big ones. I think that we can't get, I have to mention again, just the shame, just the emotional and mental stress of the process of filing for bankruptcy, and then after the fact, knowing that you're sort of starting at the bottom, even if, you had a good credit score 20 years ago before you had the medical emergency or before you had the loss of income because of a pandemic.
Thanks, Senator Cornyn. Senator Blumenthal.
Thank you, Mr. Chairman. Thank you for your continued work and your leadership on this issue. And to you and Senator Cornyn, thanks for your initiative on the Fresh Start Through Bankruptcy Act. I'd very much like to be part of that bill. And I've been working on this issue for a while with other members of this committee. Pleased to join Senator Whitehouse in introducing the Medical Bankruptcy Fairness Act. We all know that the major reason that people go into bankruptcy, the precipitating factor, is most often medical costs, healthcare emergency. And just last week, I introduced the Strengthening Loan Forgiveness for Public Servants Act, which would reform the eligibility for student debt relief for public health workers, teachers, and others who dedicate their lives to public service. Right now, someone has to work for 10 years before reaching the point where public service can be a reason for eliminating that debt. What I propose very simply is that it should be forgiven in intervals of 2, 4, 6, 8 years, so someone doesn't have to stay in the same job for 10 years in order to be eligible. There are all kinds of reforms that we can do, and some of them, as Senator Durbin mentioned, can be done administratively right now by the Department of Education. And I think we ought to put a little bit more persuasive pressure on the Department of Education to take a more enlightened approach here. But we all know that the undue hardship test, whatever it was meant to be, is really not working right now, like other parts of the bankruptcy code, quite frankly. And we've, I think, overlooked the opportunities to reform it in the past because sometimes it's viewed as technical and complex and difficult to reduce to a soundbite. But I'm particularly interested in this idea that somehow students take this debt with the idea they won't have to repay it. There's a moral hazard. Ms. Gonzalez, you just described the burdens that result from resorting to bankruptcy, and I'm assuming that students understand those consequences and wouldn't take debt with the idea they're just going to willy-nilly resort to bankruptcy to discharge it. They would go into that debt still with the idea they're going to repay it. Am I correct in that?
I think you are, Senator. I think nobody plans on being in a situation where they have to file for bankruptcy.
Because those burdens stay with people for a while, and they can be crippling in terms of getting a job, buying a house, all kinds of practical human consequences that anybody thinking about going into bankruptcy would have to consider.
That's correct.
Attorney General Raoul, is there more that you think we can do against the kinds of predatory lenders that all too often take advantage of veterans or others who may be lured into seeking degrees that aren't really going to give them the benefit of education that they think will provide careers, or the terms of the loan that may be predatory as well?
Senator, I think Yes, I mean, I think, as I illustrated in my example of Westwood, where the resources were shifted to profit instead of helping students, the notion of disgorgement of those ill-earned profits in an easier way of getting there, the notion that these institutions can rely on bankruptcy in the way that the students cannot, in order to protect them from such, is ironic at best, unjust, certainly.
Let me ask the question a different way. If lenders knew that the debtors could discharge the debt in bankruptcy, maybe they'd be a little more careful about the practices they use to lure those debtors into the debt in the first place, correct?
Certainly.
Thank you. Thanks, Mr. Chairman.
Thank you, Senator Blumenthal. Continuing with the former Attorney General's Club, Senator Hawley.
Thank you, Mr. Chairman. Thank you for holding this hearing. Thanks to all of the witnesses for being here. It's great to see a current Attorney General here on the panel as well. There are a couple of things that I wanted to focus on. The first is that while I don't support cancellation of all student debt for the reasons that have been talked about, the massive, I think, subsidy to wealthier Americans and also the massive subsidy to universities, I want to say I can't think of very many good reasons to keep students with massive amounts of debts as lifelong serfs of banks and lifelong serfs of universities by not allowing them to discharge in bankruptcy their debt under appropriate circumstances. And so I want to thank Senator Cornyn and Senator Durbin and others for their work on this, and say I think that this is a very sensible approach. And I also want to say that I think that we need to focus on the role of the universities themselves. And attention has been drawn to the for-profit universities, rightly, in terms of concerns there. Thank you for your work on that, Attorney General. But let's not let the more traditional universities off the hook. And I want to come back to what the traditional four-year public and private universities have been doing. I mean, just look at the numbers here. The annual cost of, just over the last few decades rather, the annual cost of tuition, fees, room and board at public four-year universities has increased 543%, from about $3,800 in 1985 to almost $21,000 in 2018. I mean, that's unbelievable. It's increased 483% for private four-year universities over the same time period. I mean, the only good in America, the only product, good or service in America, I believe, that has outstripped education, higher education in terms of its cost, is healthcare, which is stunning. I mean, because we all know the deep dysfunctions there. So this is totally unsustainable. I want to come back to a point that I think it was Senator Whitehouse made, that research shows that higher levels of student loan debt can lead people to delaying marriage or to not getting married, not being able to purchase a home, not being able to start a family in terms of having kids, or invest in a family if they do have kids. So it's just unbelievable. And I think that the role of the colleges and universities in perpetuating this and taking the money that has been allotted to students. I mean, the Federal Reserve Bank of New York did an analysis recently that showed for every new dollar that a college received in subsidized loans, they raised their tuition cost 60 cents. I mean, so talk about just capturing the money and pocketing it. It's unbelievable. So Dr. Akers, let me just ask you, because I know that you've looked at this. How do you think we should increase accountability on institutions that receive these student loans and are charging increasingly outrageous tuition while profiting and padding their endowments? What do you think that we can do about that?
Yeah, so to say first, if a college is really expensive, but it delivers huge dividends consistently in terms of great earnings opportunities, then good on them. My concern is that we don't have that consistent outcome. And I think that regulations should be looking at the return on investments that students are getting in order to determine eligibility for federal financial aid. The gainful employment regulations made that the case for for-profit and work training type programs. I'd like to see outcome-based accountability, meaning some measures of ROI, return on investment for the students, used rather than the current system of accreditation that we have in place today as the gatekeeper to federal funding.
Let me ask you about this. I've introduced legislation that would make participating higher education institutions liable for up to 50% of any student loan balance that goes into default and that has been used towards the cost of attendance at the institution. What do you think about that idea?
I'm a big fan of getting institutions to have skin in the game when it comes to the federal loan program. I think the concerns are the implications for equity. We know that economically disadvantaged students will be the first to lose access to enrollment opportunities as a result of that. So we need to be comfortable with that happening and potentially be willing to offset those losses with additional grants.
Well, I certainly wouldn't want to see any discrimination against lower income students or those from disadvantaged backgrounds. I mean, quite the reverse. But what I do want to see is these colleges and universities who charge outrageous amounts of tuition and do nothing currently to have any kind of accountability for it. I mean, to me, it is absolutely indefensible for these universities to be getting endowments. Like, for instance, the University of Michigan has an endowment of $11.9 billion. $billion. Harvard, $38.3 billion. Yale, $29.3 billion. Stanford, $26.4 billion. Princeton, $25.9 billion. I mean, this is, and you look at the tuition that they charge to their students. Against 4 of those are private, 1 of them's public, and I could go on. I mean, it's unbelievable. Frankly, I think it's indefensible that these colleges are charging the kind of tuition that they're charging. They're taking the federal student loan money that they're taking. They're putting students on the hook. And then they're accountable for none of it. I mean, we've got to do something about this. I also think, and I'll end with this, Mr. Chairman, I also think it's important that we begin to allow federal loan money and maybe non-loan money, Pell Grants, for instance, to go to job training and certification programs. It shouldn't be that you have to go a traditional prescribed route to this particular college, to this particular program in order to access Pell Grants, for instance. We should allow folks to take those into job training, into other certification programs, to be able to break up this higher education monopoly. Thanks to all of the witnesses for being here. Thank you for your work. Thank you, Mr. Chairman.
Thanks, Senator Hawley. Senator Lee.
Thank you very much, Mr. Chairman. I want to sort of pick up where Senator Hawley left off. We look at data going back several decades. We can see that there's nothing about the cost of higher education increase that we've seen that can be accounted for just with inflation. You know, the data indicates that back in 1985, to cover room, board, tuition, and fees, you're talking about $3,859 a year. And for a private four-year university, the total average was just over $9,000 per year. And, you know, a lot's happened since then. Wham broke up. Parachute pants are no longer cool. Nobody watches Alf or Mr. Belvedere anymore, mercifully. But the costs that have increased with higher education are staggering since then. You know, we're talking about basically a 5-fold increase since then. That doesn't even begin to be something that we can explain through inflation. So, Dr. Akers, a July 2017 Federal Reserve Bank of New York study found that there's a pass-through effect on tuition of changes in subsidized loan maximums of about 60 cents on the dollar. How does this pass-through effect explain these drastic leaps in the cost of higher education?
Well, I think federal subsidies, either through Pell Grant spending or the availability of credit through the federal lending program, have contributed in part to the inflation that we've seen. I don't think that they can explain all of it. The notion behind that pass-through of subsidies to the institutions is that basically we increase demand by giving students access to more money to spend on colleges. And when there's more demand in the marketplace, the price rises, allows the institutions or the sellers to increase their price. My other belief in this space is that we have been selling Americans on the notion that a college degree, now a 4-year college degree, is essentially the golden ticket to the American dream. I think when we've done that, we've put artificial pressure on individuals to consume higher education at any price. We have not made it acceptable for people to exist and operate in our economy without a degree. And by doing so, we have put a lot of power in the hands of the institutions to raise prices.
So it's that social pressure coupled perhaps with government backing it up in the process of doing that. I think we've got to make sure we can't control a lot of things. There are a lot of things that are not under our authority, but we can certainly look for areas where the government is making it worse. And so it's one of the reasons why I've introduced legislation called the Higher Education Reform Opportunity Act, or HERO Act. It tries to reform the higher education system in a number of ways, including by ending this sort of perverse iron triangle that often exists between traditional institutions of higher learning, the U.S. Department of Education, and the accrediting bodies recognized by such. It would also, among other things, bring about a cap in the subsidized federal higher education loans. How could caps on federal student loans, coupled with extended repayment periods, end up leading to lower tuition and to lower monthly payments for borrowers?
Well, we know that when credit is made available for students, they're able to spend more, of course. So to the extent that we constrain those dollars and students are not available to get private credit or money through other means, they'll be unable to spend the amount of money that the institution is demanding, and that necessarily puts downward pressure on prices, or at least holds them stable if we were to cap at current levels. I think the place we really want to look at doing that is in graduate and professional studies, where there could be a robust private lending market, but that we have largely crowded it out by the unbounded availability of federal credit for graduate students, and also in the PLUS loan program as well.
AEI has summarized student loan default data to try to figure out why those who default do so and what can be done about it. And the researchers preparing these findings concluded, quote, that the most consistent predictor of default risk is completion. Students who failed to complete their programs are far more likely to default than students who received a degree. For this reason, default is most common among borrowers with small balances, since non-completers attended school for shorter periods of time and thus accumulated less debt. Now, if that's the case, that most defaulters are non-completers, what measures do you think we could take as the legislative branch of the federal government to simplify the student loan repayment system and address the issue of non-completion?
I think one of the issues is lowering the period of time over which someone needs to repay their loans before forgiveness if they have a very small balance loan. We know that default rates are highest among people who have less than a $5,000 balance, requiring someone with a $5,000 balance to remain in repayment, potentially with negative amortization happening over the course of 20 years, just doesn't seem like the most appropriate policy solution.
Thank you. I see my time's expired.
Thank you, Senator Lee. Senator Hirono?
Thank you, Mr. Chairman. Ms. Barta, can you describe your own situation, particularly the choices you've had to make for you and your family when deciding where to direct the money you have? And also, would you describe how you think your life could change if you were able to discharge your student loans through bankruptcy?
Yes, ma'am. It has affected us very much so. Right now, since I had to file for bankruptcy in 2012 and still have the student loan debt over my head. Our house is strictly in my husband's name. Vehicles are strictly in my husband's name. My student loans are in forbearance right now. Well, for the pandemic, they're stopped. But if I had to pay those, there's no way I could pay $1,000 a month back and raising 2 kids. If I had been able to file bankruptcy, then we could have got a better house because I would have been able, after 10 years to put my name on the house also, be able to get a vehicle in my own name. But instead, I have to rely on my husband's credit for all that.
So, Ms. Barta, you're describing a situation in which this loan is a continual burden that colors a lot of your
Yes, ma'am.
What is happening with your family.
Yes, ma'am. Very much so.
So, Ms. Gonzalez, you deal with people who are in the kind of situation that Ms. Barta is in. How would the lives of the people that you work with, how would their lives change if they could discharge their loans?
their lives would significantly improve. We would probably have people who would be more able to afford even, the tiniest room in the tiniest house, so that they have their own place to live, as opposed to burdening their friends and families with couch surfing, or living with someone else. We would probably have student borrowers who were able to do something that I think a lot of us take for granted: save for emergencies, save for retirement. So many of my clients do not have a safety net because any income they have goes to their IDR payment.
So in your testimony, although if undue hardship can be shown, but that's a very high burden to the point where only a few of your clients even meet that burden. So we should look at making some changes to maybe defining what we mean, or I don't know, we need to deal with that. So Mr. Royal, I note that for-profit colleges enroll only 9% of students, but account for 30% of all student loan defaults, and you have gone after these institutions, many of whom just file for bankruptcy, and they totally escape all responsibility. I'm wondering whether there can be a criminal statute that applies to this kind of behavior.
Well, legislatures can propose all sorts of remedies towards various problems. So I haven't given much thought to criminal penalties, but the notion of having some vehicle towards disgorgement of those ill-earned
Yes.
profits is, and the statistics that you mentioned entering in, there's been some discussion about responsibility of higher education institutions generally, but it's important to note that 98% of the higher education institutions that have failed the gainful employment rule were for-profit institution, 98%.
So there is I would say, a lot of evidence that for-profit colleges and the degrees that emanate from those colleges do not amount to very much in terms of the ability of their graduates for employment. So you talk about disgorgement. Yes, you mentioned that a lot of these entities make a lot of money, millions of dollars, doing this, and then when they're finally caught and prosecuted by somebody like you, they just escape through bankruptcy. So I would ask you to give some thought to whether or not we can criminalize or create an ability for us to claw back some of the money that they've made over time. So if there's that kind of legislation, I'd be really interested, because it's one thing to support more Pell Grants, for example, and I'm one of the leaders in more Pell Grants, but it seems to me the more we make those kinds of avenues available, it just allows these for-profit colleges to continue to raise their tuition, and it's a vicious cycle. Thank you.
Thanks, Senator Hirono. Senator Cruz.
Thank you, Mr. Chairman. There's a concept in economics called rent seeking, whereby those with political power and influence go to those in government and seek special benefits at the expense of everyone else. Today's student loan racket, and it is a racket, I think is a powerful example of rent seeking. The people who are losing are the working men and women of this country. And they're losing on multiple fronts. Number one, they're losing because the cost of education is skyrocketing. And the cost of education skyrocketing is a direct result of policies the federal government has put in place. We've heard the stats today about the cost of education. Today, the cost of college tuition is 31 times more than it was in 1970. We've seen skyrocketing costs. In 1985, the cost of tuition, fees, room and board was $3,859 a year at a public university and $9,228 a year at a private four-year university. By 2018, those numbers had skyrocketed to $20,598 per year at a public four-year university and $44,662 a year at a private four-year university. I can tell you in families that makes a real difference. In 1957, my dad came from Cuba to come to America to go to school. He came to Austin to go to the University of Texas. His first job was making 50 cents an hour as a dishwasher. And working as a dishwasher, he was able to pay his way through school. You can't do that anymore. The fees have skyrocketed. By the time I went to school, when I came out of college and law school, I had to take student loans. I had about $100,000 of student loans when I came out of law school. It took over a decade to pay off those student loans. But the racket we have right now involves the federal government subsidizing unlimited student loans, which then sets up universities to jack up tuition and jack up costs over and over and over and over again. And the racket gets even worse because we saw in recent years, led by congressional Democrats, the federal government nationalize the student loan industry. So now it's the federal government that is loaning the money, that is directly subsidizing this massive debt burden and driving the cost through the roof. It's resulting in, at universities, people on the staff and administration getting paid six-figure sums not to teach. Not to teach, but to engage in administration. Take a university like the University of Michigan. University of Michigan right now, you can expect, an in-state student can expect to spend $130,000 during 4 years at the University of Michigan. An out-of-state student can expect to spend about $300,000 at the University of Michigan. Why is it so expensive? Well, I'll tell you, there's massive overhead. For example, Michigan has right now, the University of Michigan, has 163 diversity and inclusion employees whose job it is to be administrative overhead. To give you, put that in perspective, it has 2.3 diversity and inclusion officers for every one member of the history faculty. Our universities don't teach anymore. They are instead paid sinecures for people who go and work for the government. And by the way, they have become among the biggest donors to Democrats. It is striking just how many employees of public universities are massive Democratic donors to each of the senators up here. There's a chart I tweeted out some time ago comparing the top donors to Donald Trump to the top donors of Joe Biden. Strikingly enough, among the top donors to Joe Biden were universities and big tech. In fact, according to this bubble chart, the biggest group of donors for Joe Biden were employees of the University of California. They actually more than employees of Google, which was right behind, more than Amazon. Big education supports Democrats. And what are Democrats now saying? We're going to loan to massive loans to you. We're going to drive up the cost. And now we're going to forgive that debt, which shifts all the cost to the taxpayers. The top fifth of households holds $3 in student loan for every $1 held by the bottom fifth. What Democrats are now proposing to benefit the universities and keep jacking up costs is to transfer money from working men and women, the top 25% of households with incomes above $173,000 hold 34% of outstanding student loan debts, and yet Democrats are proposing a massive wealth transfer away from working men and women. These are policies that don't make sense. These are policies, I believe, that are rent-seeking, and they're hurting the working men and women.
Thank you, Senator Cruz. Senator Ossoff online.
Thank you, Mr. Chairman, and thank you to our panel. I want to extend a particularly warm welcome to you, Ms. Barta, hailing from Richmond Hills in the state of Georgia. It's a pleasure to have you with us. Grateful for your testimony. Please give my regards to your family. And would like to and appreciate you sharing your story with us. But just to help some of my colleagues on the committee and me to really understand what the situation that you're in means for you and your family, to talk a bit more about how the burden of debt that you incurred is impacting your family and your ability to raise your two kids.
Well, I have $120,000 in over $120,000 in student loans. My payments are over $8,000 a month, which, you know, I'm not paying right now because they're in the pandemic stop. But honestly, there's no way I can pay over $1,000 a month and raise two kids, send kids to be able to do extracurricular activities. I can't even have a car in my name, a house in my name. I mean, it's a lot. You don't know if when it comes out of the pandemic, okay, if my wage is going to be garnished because I can't pay back these student loans, and most of it's from a college that, you know, has defrauded lots of students. It's just a lot.
And you wanted to pursue a master's degree, Ms. Barta, because you wanted to engage in public service, correct?
I worked for the school system for 7 years and wanted to do online teaching, and that's why I ended up going to Ashford. It's because they told me with the degree that I got that I would be able to do online teaching as soon as I got done with it. I've applied for many jobs, never even got an interview.
Is it fair to say you were misled by the institution that was marketing that degree to you?
Very much so.
And so you took on this debt. You're unable to make the payments, unable to own a car in your name.
Yes, sir.
Unable to engage in your community and economic life and with your family in the way that you want to. And it's because you wanted to teach. It's because you wanted to be an educator.
Correct.
Well, Ms. Barta, I again want to thank you for joining us and sharing your story. And oftentimes, the Senate hears from experts, but nothing is more powerful and effective than hearing from the people who are impacted by decisions that we make, by mistakes that our predecessors in the Congress have made, by the predations of institutions that lured you in to a financially precarious situation, exploiting the fact that you wanted to make a contribution to our community and our state and our country. I thank you for your testimony. I look forward to sitting down with you in person. And you have certainly strengthened my resolve and inspired me, and I hope many of my colleagues, to take on this issue with even greater focus and urgency. Ms. Barta, thank you so much. And Mr. Chairman, I yield back.
Thanks, Senator Ossoff, and let me join you in thanking Ms. Barta for her heartfelt testimony. It really brings home the real-life impacts of this issue. Senator Blackburn.
Thank you, Mr. Chairman, and to each of you for being here today. Thank you so much. And Ms. Barta and Ms. Akers, who have joined us remotely, thank you for that. I had an interesting conversation with the Tennessee mom back during the campaign when President Biden was suggesting that he was going to forgive large portions of student debt. This was a single mom who had worked 2 jobs. Her daughter, who was now a college senior, had worked since she was 16. They had chosen junior college for her first 2 years. She would go to a community college. The daughter had continued to work in college. They had done all of this so that their hope being that she would graduate without the burden of student loans. They were diligent. They sacrificed. They saved. And she came to me and she said, okay, where is the fairness for somebody like me who has worked hard and saved and has done the right thing when you talk about discharging student loans? Now, I think that that's something that we do consider. Where is the fairness for people that have played by the rules? Likewise, we look at what has happened with private lenders and the federal government, the lack of transparency that is there, the lack of ability for people to find out exactly how they are keeping track of those loans, the interest that is due, the payments that are made. And Mr. Chairman, I think we all agree, and everyone can see from the hearing today, a need for greater transparency, a need for more diligent oversight in what is taking place around student loans, what is happening there, and how this does impact the lives. Dr. Akers, I think I want to come to you first, if I may please. As I've listened to the hearing today in your comments, we've defined problems, but I want to come to you, and then Mr. Chapman, I'm coming to you second for an answer to this. What do you think is a more effective alternative to student loan cancellation than what we have in front of us at present? And what is a more effective alternative to help those that are struggling to pay those loans? So, Dr. Akers, go ahead.
Yeah, thank you. I firmly believe that it's important that we have a safety net for borrowers to ensure that those who do everything they can to come out ahead but still have hard times aren't saddled with debt for the rest of their life. We have worked hard to create a system of income-driven repayment to provide that safety net for borrowers. Unfortunately, the system that has been created is not working very well, and there's tons of ways to reform it. Number one, it needs to be made simpler. Instead of a set of programs that student borrowers need to choose from, we need one single income-driven repayment program that students are automatically placed into when they enter repayment. So that's the first thing I'd like to see. I think we also want to reconsider the thresholds for below which students don't need to repay their loans. I found Ms. Gonzalez's testimony very interesting, and she talked about the amount that borrowers need to repay on income-driven repayment still makes standard of living unaffordable to them. That's something that we can adjust through the income-driven repayment program and the parameters of that program, rather than through a more aggressive student loan cancellation broadly, or a lenient bankruptcy policy.
Okay. Mr. Chapman?
Thank you. I agree with Dr. Akers in that the IDR program really should be reformed and have be simpler, easier to access, and much more clear to borrowers. That said, we also believe that...
so tend to it on the front end, is what each of you are saying.
Well, that's point one.
Okay.
Point two is I also think it'd be strengthened in the sense that right now it's a one-size-fits-all program no matter what your income is. And so I work with a lot of graduate and professional schools and students who have bigger debt, but also bigger incomes, and so qualify for IDR plans, which is great. And one of the criticisms of the IDR plans is that you can have someone making into the six figures and still paying 10% of their salary or 15% of their salary. And there does come a threshold where each additional dollar is more discretionary than those initial dollars. And so we've been looking at plans to have a graduated increase as income goes up,
So you
to pay
would
more.
tier it.
Yes.
Okay.
And what you can do with that is you can use that money to support the struggling borrowers more and offset some of, do the government's
So
role as
basically,
a backstop.
you would close loop that money flow.
Yes, that would be one way to do it.
All right. I know Ms. Gonzalez had some thoughts. I saw her making notes. So would you like to weigh in on this? My time is over, but I want to allow you to respond.
Sure. I would just say that the IDR program, as Dr. Akers and Mr. Chapman have said, it's not working because it's got that 10 to 15% of discretionary income, which is just based on a number, but discretionary income for one person is not discretionary income for another, because people have higher housing costs, have higher childcare costs, have higher medical costs. So that's a big challenge. And then I do just want to say that in terms of the bankruptcy reform, having this temporal discharge reinstated, it would help borrowers tremendously who are in a situation where they are at the end of their financial ropes, because they're not running for bankruptcy just to get rid of the debt. There are other reasons as well.
Thank you all. I think the problem is well defined, and I like the energy you've brought to your answers on how we find alternatives and a resolution to this. Mr. Chairman, thank you for the hearing.
Thank you, Senator Blackburn, and for your patience being at the end of the line. You have to wait till others have their day in court. I thank you for your interest in your good line of questioning and comments. And I just want to thank the entire panel for your contributions. This is an issue that I have dealt with for a long time. I came to this committee over 20 years ago, and the first assignment was reforming the bankruptcy code. My chairman was a fellow named Grassley, who was the chairman of the administrative committee, and I was a brand new senator and member of this committee. And we spent several years working on it. I was consulting with a professor at Harvard named Elizabeth Warren, and he of course, had his consultation with others too. So bankruptcy has always been an interest to me, and I think is particularly important in the context of these student loans. And what you have brought out in today in your testimony really gives me some hope. We, for the first time, are talking, and I hope you can sense this from the panel discussion here on this side, that there is bipartisanship behind this concept. And I thank Senator Cornyn especially for leading that on the Republican side. The 10 years is not a new idea. It was, I think, the law that was extant during Ronald Reagan's administration. So we've seen it work, and it can work again as far as I'm concerned. We are going to, at your invitation, Mr. Chapman and Dr. Akers, we are going to, as well as Ms. Gonzalez, we're going to embark on an evaluation of undue hardship, not as an alternative to the 10-year, but as another option, another tool that can be used for those with less than 10 years, for example. And there ought to be some reasonable definitions we can make of undue hardship. And I think there is a growing sentiment that the colleges and universities have to have, as they say, skin in the game. They have to realize they are not just giving away taxpayers' money without any consequence, that they are held responsible for literally misleading prospective applicants and students for student loans that end up burdening them in ways that Ms. Barta has spoken to over the years. I might say a word about her situation. It really breaks my heart, Ms. Barta. I don't know the exact dates that you had your experience with Ashford, but it was more than 10 years ago that a senator named Tom Harkin of Iowa did an extensive survey of the for-profit colleges and universities and made a special case for Ashford, which had bought a small Catholic college being run by an order of nuns, changed the name to Ashford, and went online and started reaping huge profits and salaries for their CEO and other officers. It was clearly a disaster in the making, and I'm afraid Ms. Barta got caught right in the middle of that and has paid heavily for it ever since. But it's a reminder, Attorney General Raoul, the importance of your job of really holding these for-profit schools, all schools, accountable for the way they spend the public's money and federal tax dollars. I'm sorry that Ms. Barta had her experience, but perhaps this administration will be more vigilant in dealing with this. So I look forward to working with my colleagues across the aisle to pass the Fresh Start Through Bankruptcy Act. The hearing record is going to remain open for 1 week for statements to be submitted in the record. Questions for the record may be submitted by senators, may come your way by 5 p.m. on Tuesday, August 10th. I want to again thank the panel of witnesses. Some of you made great sacrifices to be here today. You came a long way, Ms. Gonzalez, and you came a long way yourself, Attorney General. I thank you all for your participation, and the meeting will stand adjourned.